Good morning, everyone. I am Mandeep Kaur and I am an intern at ubAdvocate. I am very thankful to Sir Jeevan Prakash who has given me this golden opportunity to spread legal awareness. Suppose you want to produce evidence in the court of law and it is in the form of WhatsApp chat. So, can you present your WhatsApp chat as an evidence in the court of law? Let's see. Section 3 of the Indian Evidence Act defines evidence. It provides two types of evidence, oral evidence and documentary evidence. Section 3 provides that oral evidence includes all types of statements which are to be presented before the court of law, and documentary evidence involves all the documents which are to be presented before the court for inspection. Before 2000, this was the only definition of evidence. However, after 2000, there has been an amendment in the Indian Evidence Act which was done under Schedule 2nd of the IT Act 2000. After this amendment, there are two sections that has been added in the Indian Evidence Act, and that are firstly 65A and 65B, which relates to electronic evidence. So these new sections provides that electronic record can be accrued evidence. It can be given as an evidence in the court of law. Section 65A provides that contents of an electronic record can be presented in the court of law if all the conditions of the 65B will be met. Section 65 provides for the conditions that are necessary for the admissibility of the evidence. It provides that if any information contained in an electronic record that is printed in paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed as a document, and such document shall be admissible as evidence without further proof or production of original if the owner or person responsible for the computer who recorded the evidence gives a certificate under section 65B subsection 4 of the Indian Evidence Act. It means that a certificate is very necessary for giving evidence as an electronic record. So before the amendment of 2000, electronic evidence was either admitted through primary evidence or secondary evidence. But after the amendment of 2000, it is now admissible under section 65A and 65B. So yes, your WhatsApp chat can be admitted as an evidence in the court of law. However, there is some confusion and conflict regarding the production of certificates while giving electronic evidence. In this, we will cover 4 major Supreme Court judgments which resolves this issue. The first is State and City of Delhi versus Navjot Singh Sandhu. In this case, it was held that the certificate under section 65B is not necessary and electronic evidence can be given through section 63 or 65. However, in the other case, Anwar versus Bashir, it was held that the procedure that is laid in 65A and 65B must be followed. This view was overruled in another case, that is Shafi Muhammad versus State of Himachal Pradesh, where it was stated that the procedure that is given under section 65A and 65B is merely procedural and it need not be followed in all the circumstances or situations. But lastly, there was in the judgment of Arjun Pandit Rao versus Kailash Kushan Rao, this confusion regarding the production of certificate was resolved, and it was held that the procedure that is given under section 65A and 65B must be followed. Only then you can give evidence through electronic record. That means a certificate is a must for giving evidence. So this was all about section 65A and 65B, which has played an important role in today's world, in the cyber world, and has helped our Indian judiciary immensely. Thank you so much.